165, People versus Ambers. Counselor, go ahead.
Good afternoon, Your Honors. 2 minutes, Your Honor.
2 minutes, sure, go ahead.
Good afternoon, Your Honors. May it please the Court, Mark W. Vorking of Appellate Advocates for Appellant Nugene Ambers.
So what's the turn and deal here?
The facts in this case are distinguishable as to the Turner issue, Your Honor.
Go ahead.
To address that specifically, in this case, counsel affirmatively took the position that he did not want the jury to compromise and to simply convict solely on the two misdemeanor counts here. The defense at trial consistently throughout was actual innocence, was that the two complainants in this case were simply not credible and that none of the claims that the people had put forward were supported by the evidence. As a consequence of which, during summation, counsel specifically asked the jury that the only just verdict in this case was an acquittal on all counts. Thus, like in Turner and unlike in Evans and other type of Turner-like cases, counsel here affirmatively rejected the compromise, which could have only been the only conceivable strategic reason to leave those time-barred misdemeanor counts in here. Thus, because counsel failed to seek dismissal of those counts, counsel was ineffective for him.
Are you saying, counsel, that even though defense counsel at trial didn't say, I don't want to compromise, but his strategy was to get an acquittal on all counts, that he effectively said, I don't want to compromise?
Absolutely, Your Honor. Absolutely, Your Honor. And I think that there's no other way to read counsel's actions in this case is to seek an outright acquittal and no compromise on the misdemeanor counts.
Are you saying that that's never a good strategy?
No, absolutely not, Your Honor. I think in some case it could be a strategy, but it was not the strategy advanced here.
Why was it a bad strategy here?
Well, I think because the strategy advanced here was that the client, that Mr. Ambers, was factually innocent of the charges that the people had brought. And that strategy entailed seeking an acquittal on every single count of the indictment, which is precisely what counsel did. And I think that's why, in many respects, Evans is actually sort of helpful in understanding the Turner issue in this case, precisely because in Evans, counsel did precisely that, Your Honor. Counsel sought a compromise as an alternative disposition that the jury could consider, asking them to drop down.
That's what I keep saying. You can't ever ask for an outright acquittal as a defense lawyer?
I'm sorry, Your Honor?
You can't ask for an outright – what am I missing? You're saying that because he didn't ask them for a compromise verdict, he was ineffective?
Yes, Your Honor.
All right. Why couldn't he just ask for an outright acquittal?
Well, I think counsel did ask for an outright acquittal.
I'm sorry, yeah. What's wrong with that? Why would you not do that?
I don't think there was anything wrong with that in this context.
Oh, okay.
I guess the question, perhaps, that Judge Piggott's questioning leads me to think of is, if indeed that's what he's thinking, why can't he hedge? Why can't defense counsel hedge bets in favor of the defendant and keep them all, keep all those counts, thinking I may not be able to persuade them of innocence, but maybe I can get them to find him guilty on the lowest count.
You know,
why isn't that an appropriate strategy? And can we even discern that from the record?
Well, I think the record affirmatively disproves that strategy here.
Well, let me ask this about the record then. I know you want to get to that point, but
yes, Your Honor.
Turner issue, and the statute of limitations blown on the EWOC, on the endangering the welfare of child we're talking about, right?
Yes, Your Honor.
All right. So it's not dispositive of the case because this is only a partial Turner, once again, like the previous case was. The same kind of problem we had before. Turner talks about you being able to dismiss it if it's dispositive. Otherwise, then we have to look at whether or not counsel was effective.
Right.
But here there's no 440 motion, has there been?
There is no 440 motion.
So we don't have any record at all of what counsel was thinking or wasn't thinking, and so forgetting about if there, so we're basically have to discern whether or not there was a legitimate strategy in the absence of any kind of record on the issue.
In the absence of any, I think, off-the-record record that would come about in a 440 context, but I think, Your Honor, our position would have to be and I think that counsel's summation in this context makes clear that he did not want a compromised verdict. And
yeah, see, maybe I'm different than I'm not sure that I don't think there's anything wrong with saying I don't want a compromised verdict, but I'm happy if I get it. You know, that's he goes for everything. If he doesn't get it, he takes what he gets. But he's doing the best he can for his client. I understand that strategy. That just seems to be good advocacy for me.
Well, Except I think that many other things occurred in this case which demonstrate counsel's ineffectiveness, separate and apart from the
Well, you
termination.
can go to the prosecutor's summation. I think that you might have a stronger argument for that.
Exactly, Your Honor. That would be our principal argument as to counsel's ineffectiveness, would be his failure to object effectively to a barrage of prosecutorial misconduct during the summation.
Well, he did object numerous times, did he not?
Well, counsel said the word objection several times, repeatedly. But as this Court has held time and again in Love, in Medina, in Gray, in other cases, simply saying the one word objection does not constitute an objection. Simply
That may be, but when there are so many objections that you're making, and in fact you do state the basis for some of them, might it not be a reasonable strategy to say, you know, gee, if I keep repeating myself over and over again as to the basis for my objection, A, I may be focusing the jury on what the prosecutor is saying, and B, I may be annoying them. So I'll just get my objection on the record, and, you know, the court knows what to do.
And this Court has held that in Taylor, for example, but Taylor is not this case. I think that in this case, this is a counsel who did not fear interrupting the judge. As I think as Your Honor said, counsel did interrupt those few times where he actually identified the prejudice that was occurred to the client.
Right, but I'm talking about the sheer amount of times that he would have had to have done this.
I think that all counsel had to do here, Your Honor, was articulate the basis for his objection. And I think I would urge the Court to look at the colloquy after the prosecutor's summation, because I think counsel, yes, he makes these standing sort of objections, these general objections, which are no objections of all, but then when he's given an opportunity to articulate the basis for why he interrupted previously, he limits it to two discrete issues. The affirmative misstatement regarding the testimony of Hoff and Rosenfeld, which in and of itself is extremely problematic in this case, where you have uncorroborated allegations of two young complainants.
You had pretty strong curative instructions on that, though, didn't you?
There was a curative instruction, but again, it fell after the fact and did not occur, and the mistrial motion was denied during the course of the summation, and it only went to whether or not the record supported the prosecutors, which she later admitted was not supported by the record, that the client was intoxicated when the abuse occurred. Counsel did not, as he could have done and as he should have done, because he surely realized how prejudicial that type of misconduct was, to point out to the Court and to ask for a curative instruction or a mistrial on the ground that all of the propensity arguments concerning the fact that the client was drinking and thus he must have abused the complainants in this case.
You mentioned the mistrial. I believe trial counsel asked twice for a mistrial, and one of those times was around the statement that the defendant committed these crimes while he was drunk when there was no support in the record for it.
That's true, Your Honor.
And there were curative instructions, and as Judge Stein said, there were a number of objections here, 30, I think, in total, and half of those were sustained. So are you saying for the half that weren't sustained, that counsel was ineffective because he didn't articulate some sort of basis for the objection?
Well, let me be clear here. I think that, and our brief lays out this in far more detail, but there was a variety of misconduct that took place in this case. Yes, counsel did say the word objection in response to misstatements about the record concerning the drinking, concerning Hoff and Rosenfeld's testimony. Counsel made absolutely no objection, did not interrupt at all regarding inflammatory remarks about the client being a predator, preying on these girls, shifting the burden of proof, concerning how appellant testified on the stand and that, of course, he did it. This is one remark that the prosecutor made during the course of the summation. And then, of course, never getting to the propensity issue, which really is, I think, the most problematic form of misconduct that occurred in this case, by which the prosecutor focused on the client's criminal history and urged that because he struggled with alcohol at a period of life, he was the type of person who would commit this type of abuse. That was never raised by defense counsel in this case. No curative instruction was given. And it's that type of misconduct that this Court has particularly focused on, especially in child sex abuse cases, as this Court recognized
You'll have your rebuttal.
Fisher and Wright.
Let's hear from your adversary.
Good afternoon, Your Honors. May it please the Court. Anastasia Spinakos on behalf of Richard A. Brown.
Counsel, what about the applications for the mistrial over and over again? Did the judge abuse his discretion in not granting them when clearly so much of this was propensity, the alcoholism? Do you think there were no legitimate grounds for mistrial?
I would urge Your Honor to look at the record in totality here. and what the court did here, and the court cured any potential error that occurred.
You think they cured the error? You don't
Completely.
think there was a propensity of the worst kind argument being made here and over again, and not necessarily because counsel was ineffective, maybe because the opposite, because counsel was in their face all the time and maybe pushing the prosecutor, and the prosecutor took the bait, and basically all about propensity, isn't it?
No, Your Honor.
Why not?
The trial prosecutor did not make a propensity argument here. What defendant does on this appeal is he labels some of the prosecutor's comments, and he takes them and he uses labels like propensity, shifting the burden. But that's not what occurred here. When you look at the summation in totality, and when you look at the comments made in the context that they were made, the prosecutor was not making a propensity argument.
What about the alcoholism? And is there any proof to support all the things he said about all the things that the prosecutor said about alcoholism causing each of these things? Is there anything that supports that?
The prosecutor's comments were fair comment on the evidence that was adduced here at the trial.
I'm asking you, on the evidence that was adduced, is there any basis for this over and over again, this business with alcoholism at each one of these mileposts caused this? Where does that come from?
That comes from various places during the trial, Your Honor. That comes from defendant's written statement, where he said, and this was admitted into evidence, I used to drink a minimum of 200 ounces of beer right after work.
Yeah, but wait a minute. There's it's hard to sort out. There's so many objections, and I think one of your defenses to that is it was fair comment on what the defense said in its summation. Am I correct?
Yes, it is.
And that always seems problematic to me. Why don't you object when they make inappropriate comments in their summation? I mean, can you not do that? Can you sit back and say, here's another opportunity for me on fair comment to call a guy a two-time felon, a drunk, a pervert, et cetera? I mean, it always seemed to me that the people ought to be on their feet when there's something to object to in the defense summation.
And the people did object a few times, but there also is a theory that objecting when defense counsel is up there trying to make a summation could, make the jury look like you're trying to hide something, you're trying to stop them.
Which is your way of saying, how come they didn't object during yours? I mean, I don't get that. You're saying, well, he didn't object to this, he didn't object to that, he didn't preserve this. Maybe he didn't want the jury to think that he was trying to hide something. This back and forth on summations, it gets a little troubling like that. Because you want to say he didn't object to some parts of the DA's summation, therefore it's not preserved. I want to say that you ought to preserve objections to the defense. He said, well, no, we're not going to do that. That's good trial strategy on us. We're not going to. And I don't get that. I don't understand why that you wouldn't object if there's an objectionable thing in the defense summation and ask for appropriate instruction, rather than saying I can comment on that in my own and call it fair comment. Am I making sense?
I think I understand where you're going with this, Judge, but I don't think that was that the trial prosecutor looks at it that way. They object when they think something is that egregious, but there is a large plane, you say, where a prosecutor and a defense attorney can go in their summation. There's comments they can make based on the evidence, comments they can make that based on the inferences from the evidence, and the rhetoric that you're allowed can go pretty far. A prosecutor, I don't think, looks at it that I'm going to let them go so far so I can go that far. I think you're presuming a bad intent on the prosecutor's part, which you shouldn't do.
No. What I'm saying is that you're justifying what may be out of bounds on your summation by saying they were out of bounds on theirs.
It is proper for us to respond to their comments. This
Right.
Court has
I'm
always
saying
said,
maybe you should be objecting to their comments if they're inappropriate.
we did object to a few of them, but we didn't object to all of them.
And you're saying you didn't object to all of them because you didn't want to appear to be trying to hide something in front of the jury.
That could be a strategy that the trial prosecutor
And my
had.
point on the other side is that yet you're saying about the defendant, he did not object to what we were saying in our summation. So why wouldn't you apply the same rationale that maybe he didn't want it to appear that he was trying to hide something from the jury?
What I'm arguing that defense counsel, he did object several times.
Right.
And his failure to object doesn't demonstrate that he was ineffective. Okay? when you look at counsel's representation, you have to look at the totality of the representation from the onset all the way to the end.
I looked at one of them in terms of appealing to the emotions of the jury, rather, and as the defense counsel pointed out, where the prosecutor called him a two-time felon, a drunk, a predator who had stolen the complainant's innocence, scarred them for life, saying the complainants deserved an Oscar if they lied, and there was no evidence that they would lie, and misrepresenting the people's child sex abuse expert's testimony, and failed to seek dismissal of two clearly time-barred counts.
Judge, you're taking a lot of comments that were made sporadically in different parts of the summation, and you're putting them all together. And when you do that, of course,
Yes.
it doesn't sound very good, and
Right.
they're very bad sound bites. But when you put them, it's a 33-page summation. When you put them through the summation, and most of the arguments she was making were proper, and most of the arguments that she was making were responsive to defense counsel's argument. He had only one avenue to take here, defense counsel, and he had to argue that the victims were incredible. He had to argue that basically they lied. He didn't use the word lie, but that was his argument. They fabricated this. They were angry. They had motive. He had all these
You
reasons.
considered vouching for the truth of a witness when you say they deserve an Oscar?
That, Judge, actually, that comment was proper and responsive. In voir dire.
No, I think you misunderstood my question.
Okay.
Do you consider that vouching for the truthfulness of a witness?
No, that's not vouching.
That?
No.
Okay.
The prosecutor, when defense counsel says that these victims are fabricating everything, that they've actually completely made the story up, that this never occurred, and he said this several times, this never occurred, okay, the girls basically colluded with each other, and were angry over other things, minor things, their sister not getting toys from him, whatever it might be, and that they had the seed planted by the friend about the story that they learned in the Bible study class. When you say all of that, what defense counsel is arguing is they got up there and their testimony was completely credible, okay, as the trial court noted and said at sentencing. Their testimony was compelling, impressive, and very believable, okay. The girls got up there. Another thing that the prosecutor commented on summation is that the girls were very emotional during their testimony. They were crying and they were breaking down, okay? So the prosecutor's comment that they would have to be actresses if this was all, a show, if this was all false, is not vouching for them. It's explaining to the jury why the victims were credible, why they should find them credible. Defense counsel discredited them completely in his summation, and we're allowed to turn around and respond to that and explain to the jury why we find them credible.
Yeah, I get the explaining. I just didn't. I thought, saying they deserve an Oscar is kind of
Well, Judge,
vouching for their credibility.
I'd like to point out to you also that in voir dire, counsel questioned an actress and asked her about being able to put on emotions on cue, cry on cue. And the trial prosecutor's comment about the Oscar.
So when you objected to that at voir dire, what was the judge's ruling?
I don't believe that was objected to at voir dire, Your Honor. Both the errors here that you have to consider, there has to be clear error, there also has to be some prejudice to defendant. And when you view the totality of the record, okay, defendant received a fair trial. His attorney was effective throughout, did many, many good things throughout. And nothing that he raises here rises to the level that counsel did not provide meaningful representation. And if there was any error here by any of the prosecutor's comments, that was completely cured by the incredibly thorough curative instructions that the court gave during the final jury charge.
Thank you, counsel.
Thank you very much, Your Honors.
Counselor Rebuttal.
Thank you, Your Honors. Just a few brief points.
Go ahead.
I would urge Your Honors to look at Wright, People v. Wright, was decided this past summer. I think Your Honors spoke very eloquently about how a serial failure to object to misconduct in and of itself, where there's no strategic rationale to do so, is tantamount to ineffective assistance, notwithstanding the fact that counsel may have pursued a rather effective defense strategy otherwise. And I think this case is sort of...
But in Wright, the prosecutor, of course, was misleading the jury as to the nature of the scientific evidence, which is not this case.
Absolutely, Your Honor. I think the type of misconduct is slightly different because of the DNA.
Couldn't we find an abuse of discretion by the judge and still find that counsel was effective?
You could, Your Honor. You could, Your Honor. I think that's why
You argue that?
we did, Your Honor.
So why-
We argued that the misconduct in and of itself and the court's failure to give to essentially grant the mistrial motions that counsel made as to the issues that he did
You
preserve.
don't believe that everything was cured by the judge?
No, we do not, Your Honor. These were objections that were made during summation. Mistrial motions were denied repeatedly by the judge during the course of that summation. And yes, a curative instruction was later given, but as this Court has recognized in Calabria and in Rybeck, curative instructions may not be sufficient whether the misconduct at issue is sufficiently egregious, as it was in this case. I just want to add one quick point about the Turner issue. I really think ineffectiveness always turns on whether or not the defendant received a fundamentally fair trial. It is fundamentally unfair for a defendant to be convicted of time-barred counts and for that conviction to stand. Thus, as the Turner issue, we seek dismissal of the misdemeanors on that principle.
Okay. Thank you both. Appreciate it.